tonight's edition goes into a very important aspect of the functioning of our democracy. Viewers, judges decide matters of life and death. Their pronouncements cannot just change the fate of an individual, of a litigant, but an entire nation. The quality of judges and the vibrancy of the judiciary is necessary for a healthy democracy. This may sound like a cliche, but it is true. But judgments and decisions pronounced from the bench can only be as good, viewers, as the people who deliver them. If judges hold the destiny of a people and the nation in their hands, then it stands to reason that judges must be of unimpeachable character, but also of unimpeachable credentials. How do you appoint judges of unimpeachable character and credentials? That's the fundamental question. Obviously, through a system that guarantees such an outcome. In India, there is, however, a debate raging over whether the current system to appoint judges is in itself unimpeachable, tamper-proof, and transparent. Many believe that a system where judges appoint themselves in a manner of speaking without outside scrutiny and with a fair degree of secrecy cannot be trusted. In fact, viewers, let me tell you that at one particular point in time, the Supreme Court had admitted that the proceedings of the Collegium were absolutely opaque. The present system in India sees 5 judges of the Supreme Court pick not only their colleagues to the Supreme Court, but also justices to high courts across the length and breadth of the nation. Simply put, viewers, the Constitution says that judges should be appointed through consultation. But where is the consultation if a group that has already decided who to appoint can't be stopped from doing so? Bizarrely in India, while the executive can return the recommendations made by this group or collegium of judges, once the collegium sends back the file of recommendations, that decision is binding. Ironically, the Supreme Court also sat in judgment of a challenge to the existing collegium system. The Parliament had passed a law for the creation of a National Judicial Appointments Commission, where 3 senior-most Supreme Court judges, the Union Law Minister, and 2 eminent personalities chosen by the Chief Justice of India, the Prime Minister of India, and the LOP would decide on the appointment of judges to the Supreme Court and the High Court. But viewers, this system, even though it was numerically loaded in a manner of speaking in favor of the judiciary, was rejected by the Supreme Court judges themselves. Though a lot of time has elapsed since then, the government has sought to re-engage the Supreme Court in evolving an appointment system that isn't, according to the government, as closed as the existing collegium-based one. The Law Minister, Mr. Kiren Rijiju, has written to the Chief Justice of India demanding that members of the government be appointed to the Collegium. While we are not suggesting that this precondition satisfies the test of transparency, can it be denied, viewers, that the present system breeds opacity? Let's ask the question of our eminent panel tonight. And I want to begin first with Justice S.N. Dhingra, former Delhi High Court judge. Justice Dhingra, when until the early 90s, judges were appointed by what many people believe is a truly consultative process between the executive and the judiciary, why rely on an opaque mechanism such as the collegium system? And if we are not to rely on this, is the government's suggestion today to the Chief Justice of India agreeable to you? Justice Dhingra.
See, I don't think this is going to serve the purpose for which the lot of debate is going on in judiciary and outside judiciary. The issue was that the opaqueness of this collegium system must go, and there should be another system in which the people know why the judges are being appointed, from why a particular judge has been appointed, what are his qualifications, what is his experience, what is his standing, and what merits he has vis-a-vis the other people which were considered. Today the system is that nobody knows why the particular judge has been considered as worth appointing to Supreme Court. No minutes of meeting are recorded of Collegium. What merits he had are not discussed. The people in fact know from before who will be appointed as a judge of Supreme Court or High Court, looking at the Collegium faces and who is Chief Justice and who are his colleague judges. So people can predict that who will be the judges appointed by this Collegium. If this is a system going on and people are criticizing it, I think addition of one more member from the government is not going to help to improve the system. The system will remain opaque and the system is not going to change. What will happen is the bartering will be there between government and the Collegium, and some persons of Collegium government will also be there. Now there are persons only of Supreme Court. See, there are many aspects of judicial reforms which are not even being discussed. That is very unfortunate.
Okay, let me bring in Mr. Salman Khurshid. Mr. Khurshid, we might of course disagree on the manner in which the government has intervened in the last 24 hours. We may not think that that perhaps is the best way forward. But do you believe, Mr. Khurshid, that the time has come for sweeping reforms in the appointment process adopted as of now for judges?
Well, yeah, it's a difficult question at this point, and I say it's a difficult question at this point because I'm aware that in the past NJAC was the brainchild of my party. That we were concerned about the need for reform in appointment of judges, and we thought about it seriously, and we came up with what we thought was the best model at that time. Now it's another matter that the judiciary, much as we wanted the judiciary to understand the intent of what we were doing, the judiciary was unable to accept what we had done. And let me assure you that we had consulted very extensively with some of the outstanding former judges of our country, many of whom had some brilliant ideas and were equally concerned as we were about how to go forward. But I do believe that the overall atmosphere has changed so dramatically that we have some worry about even the propositions that we had placed before the judiciary in the NJAC Act, and we are now having to think very seriously about how best it could be done. And I think that nobody seems to have a clear-cut idea of answering the concerns that we all have, including the judiciary.
You made an interesting point, Mr. Khurshid. You said that even the formulation that we had come up with, perhaps in the current environment, may not be conducive. Now that's interesting because At that time, the Parliamentary Standing Committee of Law and Justice in 2013 had said, and I quote, "The present process adopted by the Collegium of Judges is beset by its own problem of opacity and non-accountability, besides excluding the executive entirely in the collaborative and consultative exercise for appointment of judges to a bench of the higher judiciary. Because of its inherent deficiencies in the Collegium, as many as 275 posts of judges in various high courts are lying vacant, which has a direct bearing on the justice delivery system and thereby affecting the judiciary." And of course, the cabinet under the UPA at that time had accepted this report and then promulgated an NGAC of its own, which you have now, of course, told us about. Why is it that the Congress was perhaps better equipped and this government is not?
Well, not a question of Congress being better equipped and this government not being equally equipped. I think that you learn from experience, and I think today we have the experience not only of what the judiciary's response and reaction was, but also being able to look beyond what we understood at that time and perceived at that time. And there are many difficult issues that are today arising. I think even the discourse or the manner of the dialogue between the executive and the judiciary leaves a lot to be desired. But you know, the more one speaks of this, the more I think unfair and unkind and uncharitable we will be becoming to the judiciary. I think a lot of this, despite people who believe that there should be less opaqueness, etc., I think a lot of this needs to be in closed doors. This is a very sensitive institution, a very valuable institution, and we can't be talking about it and dissecting it out in the public all the time.
From the little reading I've done of what Mr. Sibal had said, very clearly he says, just as judges have enormous stake in the appointment of judicial officers in the higher judiciary, Supreme Court and the 24 high courts, the government has an equal stake. Since both of us have stakes in the appointment of members of the higher judiciary, the consultation of both of them is absolutely necessary. The government must have a say. So he was pretty much speaking the same language as the current law minister, Mr. Rijiju, is speaking. Mr. Ranjit Kumar, is there a difference here? And do you sense that the Congress today is perhaps wary of throwing in its lot with this government because of...
990 said that the present collegium system, I am reading from the book, present collegium system lacks transparency, accountability and objectivity.
Yes.
There is a trust deficit. Deserving persons have been ignored wholly for subjective reasons. Social and other national realities were overlooked. Certain appointments were purposely delayed so as to either to benefit vested choices or to deny benefits to the less patronized. So therefore, this paragraph of the judgment of a majority opinion judge itself says everything what the government today is saying. And that is what the common refrain today is about the objectivity, accountability and the selection process itself. That's my first thing. The second thing is that the consultative process which is mentioned in the Constitution has been brought into a no consultation, only I am going to decide.
Yeah.
That has brought about this situation today. So therefore there are sensitivities involved. If you ask a retired Chief Justice or a retired judge, he will say the collegium system has failed. But while the persons within the collegium may disagree with me, may not disagree with me, well, it is their prerogative. And there are sensitivities involved here because there are persons who are overlooked. And if persons are overlooked who are senior and juniors jump the queue, then also within the judiciary there is dissatisfaction. High Court judges feel that I will be selected because I am senior and I am good. but then they are overlooked for reasons which are not known.
Interesting.
Thank you.
Because I think who you're quoting is Justice Kiren. And let me bring in Sanjay Hegde, Dr. Ranganathan and Mr.
That's
Lekhi. In this judgment, Sanjay Hegde, Justice Kiren has said, and I quote him, all told, all was and is not well. To that extent, I agree with Justice Chalameshwar that the present Collegium system lacks transparency, accountability and objectivity. The trust deficit has affected the credibility of the Collegium system as sometimes observed by the civic society. Quite often very serious allegations and many a time not unfounded too have been raised, and its approach has been highly subjective. And it goes on, as you know. I feel that it's not the trusteeship that failed, but the frailties of the trustees and the collaborators which failed the system. To me, it is a curable situation yet. Now, Mr. Hegde, if the government is interceding, let's say on behalf of the people, let's give them the benefit of doubt. Let's not think that there is a motive here, though you may want to attribute one, or the former law minister on the panel, Mr. Khurshid, might have his suspicions. But let's for a moment suspend those and say that this government wants to intercede to make sure that we have the best, giving the best judgments in the interest of public welfare. Why can't the government make this intercession at this point?
If the government wants to intercede, then it has to do it again by a constitutional amendment. You cannot set aside judgments of a constitution bench. You cannot go back to a constitutional amendment which has been struck down, and no letter of a law minister or anybody else can amend the system which has been put in by several constitution benches. You want to change the system? Please change the constitutional provisions. They may be tested again on judicial review. They may succeed, they may not succeed. But you can't say, okay, please forget what the constitution bench has said. Please forget all your judgments and just give me a seat on the table. That is certainly not on. This letter was ill-advised. Yes, there are problems with the Collegium system. If there are problems and the government wants to amend the constitution, so be it. You cannot reduce the constitution to something like which can be set aside by a mere executive decision or an executive order.
I just want to ask you, world over, in established democracies, the norm is for the executive and the judiciary to collaborate transparently in the appointment. So why is there this exception in India? Do we not trust the judgment of, as you yourself have suggested, people like the Prime Minister, the LOP? The NJSC sought to have a wider consultation. There was the opposition, there was the Prime Minister, there were people chosen by the Chief Justice of India, eminent, that is, justices, etc. So how is that an unrepresentative structure that gives the executive above and beyond powers to influence?
No. The executive has the power to intercede. The executive could even suggest things. But the executive can't be part of the judiciary. When the judges make recommendations, that is part of their judicial functions, and it is safeguarding the independence of the judiciary. You can't have the executive there at that stage. The executive can say, okay, you've made this recommendation. I don't think that is right for X, Y, or Z reason. If the executive shoots down somebody saying for these reasons, the judges accept it, fine. If it puts out reasons and the judges say we know those reasons, but despite that we think that this man would be a good judge, then the current law is that the judiciary's recommendation prevails.
Well, I find that a little odd because you haven't addressed the question I asked you, that in some other advanced democracies, the executive does have a say. So you're sort of saying that keep the executive out. And it's also a little odd because barring the emergency, some of India's momentous judgments, like, for example, the Kesavananda Bharti judgment that gave us the basic structure doctrine, were delivered by judges that were appointed with a greater say for the government. So why can't the NJAC that provides a reasonable balance be upheld?
It's precisely because of Kesavananda Bharati that certain judges got superseded. and because of Keshavananda Bharati, that you then had the emergency and the whole experience thereafter, where the government of which got re-elected at that point of time, started fiddling around with judicial appointments. We in the subcontinent have tended to keep at least the process of initial selection and recommendation to the government within the judiciary.
Well, let's also not forget that under the Constitution, the CJI had a consultative role in the appointment of judges, with the president holding the powers of appointment. Now, I don't know why that got lost, superseded, etc., squeezed out of the system, and we can talk a little bit about that. But I just want to get more comments in. Former ASG, Aman Lekhi, where do you come in on this? The executive should have no role. So the present law minister is completely out of his brief in some way, is completely transgressing his brief by even writing to the Chief Justice of India. How do you respond to that?
Well, firstly, what I want to say is that no system is permanent or perfect. And because the system is not permanent or perfect, it's open to change. And change need not necessarily be bad. However, that said, when we are governed by a polity which is in some way regulated by law, change has to be legally sanctioned. And here, the method, you use the word engage. Here, my objection is the manner in which the engagement is taking place. Now, it does not, in my opinion, behove a law minister to write a letter to the Chief Justice on a question of appointment, when the method of appointment, whether we like it or not, stands settled by a judgment. Now, letters cannot alter judgments. It is for the law minister to take appropriate measures, either to have the judgment reconsidered or to bring a new law. What my objection to this entire exercise is that a very serious issue becomes reduced to one where a politician plays to the gallery to excite emotions about an institution, to suggest that as far as the institution is concerned, the institution is in some way acting as a barrier to whatever development agenda the government may have, so as to create some kind of ill will towards it. This is what my primary objection here is. It would have behoved the law minister, because he said he's acting in terms of the Supreme Court directions. Now, if he has to really act in terms of Supreme Court directions, firstly, what was very necessary was that the memorandum of procedure to which reference is made should have been finalized. The memorandum of procedure has been pending consideration in 2017, that is post the judgment, and it is going to and fro from the court to the government. So why is the law minister silent as memorandum procedure, and why is the memorandum procedure important? The memorandum procedure is important for the very reason it's talking about. It had dealt with eligibility, it dealt with age, it dealt with complaints and a secretariat. It had a structure in place for the purpose of memorandum procedure. Now there's disagreement as to what the procedure is. Firstly, that is. Number two, how does the government act in this particular case? Now, insofar as the involvement of the government is concerned, one, both at the time of sending the recommendees to the Collegium, and two, after the Collegium makes a recommendation to consider those who have been sent, the government sits on it. And when the government disagrees, the government doesn't come up with reasons for the disagreement. Now, as far as opacity is concerned, when the relationship is interactive, and you have at both ends the court and the government, the requirement of transparency will be equal where both are concerned. So what the law minister should also have addressed is that as far as this question of the government returning, does the government set out reasons for returning? Now, if the government doesn't set out reasons, we are not here dealing with politics. Politics is not.
True, I understand that.
So what I am saying is, these are sensitive issues to be seriously addressed and not be made the subject matter of petty politicking on either side. And an example should have been set by the law minister to be a bit more responsible in his comments and restrained to in fact put this matter in the correct perspective and specify the lapses at both ends of the system, because they are there at both ends. It's not a question of opacity of the judges only. So okay. I personally feel
I find this interesting because, are we treating the justices like people incapable of introspecting? Do they need to be forced and kick-started to reform? I mean, we are putting all the sort of onus on the executive, etc., bring a law, bring a new law. What about the justices themselves? I'm sure they have a higher conscience, and let's not say for a moment that the judges themselves are not above playing to the galleries. So if there is a problem and that problem exists, doesn't it devolve upon the judges themselves to perhaps come up in a manner which behoves their station to do the reform? Mr. Lekhi, why should we only be sort of saying, oh, come, we have to force you into doing something? Shouldn't the justices be aware of what, for example, Justice Chelameshwar said when he gave the dissenting judgment in the NJAC verdict? He said the fiasco created in the Dinakaran case and Shanti Bhushan case would justify the participation of the members of civil society in the process to eliminate from selection process the malafidis involved in the process pointed out by Ramapal Justice. The above mentioned two are not the only cases where the system failed. It's a matter of public record. I mean, he says matter of public record, that in the last 20 years after the advent of the Collegium system, number of recommendations made by the Collegia of High Courts came to be rejected by the Collegium of the Supreme Court. There are also cases where the Collegium of this court quickly retraced its steps, having rejected the recommendations of a particular name made by the High Court Collegium, giving scope to a great deal of speculation as to the factors which must have weighed with the Collegium to make such a quick volte-face. Such decisions may be justified in some cases and may not in others. There is no accountability in this regard. The records are absolutely beyond the reach of any person, including the judges of this court, who are not lucky enough to become the Chief Justice of India. Such a state of affairs does not either enhance the credibility of the institution or good for the people of this country. So why should, if this is the case, the Chief Justice of India and other brother judges be perpetuating such a system, Mr. Lekhi?
Well, you see, there's a basic flaw in what you're saying.
Right. I'm not saying. Justice Chalmeshwar is saying. Please. Thank you.
You are quoting Justice Chalmeshwar to make a point.
Right.
To suggest that as far as the judges are concerned, they have an authority of their own to alter the system. That is, there's a subjective element which is vested in individual judges to change the law at their whim. This is what you're suggesting, because the law minister suggests. This is what you're suggesting.
No. I'm not even talking about the law minister.
No,
I'm saying that if a system is broke and brother judges are aware that it is broke, you yourself are saying it's broke. Should it not devolve upon the justices themselves to come up with a solution?
Yeah, I know. Come up with, that's what I'm saying. So what you're saying is that because there's a change, there's a need for a change, and the law minister suggested a change, the judges should of their own take the initiative to bring about the change. This is broadly what you're saying. Yeah. And unless they do that, they are the ones who are in the wrong. Now, this
I'm not saying they're in the wrong. No, don't put any words in my mouth.
They are deficient in some way, and they're
perpetuating a system that is not obviously doing the best by public interest. That's all.
May I answer? Yeah. Now, the question, what I'm trying to tell you is, for the very reason the law minister could not have written a letter, and for the same reason the judges cannot on their whim ignore the mandate of a judgment. Because the judgment stands, and whatever the view of the judges may be, whether you like it or not, and that's a system of that is how we are governed by the system. Whether we like it or not, we have to follow the law. And because we have to follow the law, we have to alter the law in the manner law mandates. And no one would know that better than the law minister. Now, that is exactly what I'm saying. When you mentioned playing to the gallery, I say that deliberately and repeat it. It is playing to the gallery because he knows that the letter is not going to have any effect. It cannot possibly have an effect because the effect can also be in a manner.
No, but maybe, Mr. Lekhi, maybe because of the renewed debate, it will nudge people in the judiciary who seem to have sort of adopted an ostrich-like approach, especially after the 16th of October 2015, when the Supreme Court itself said to consider introduction of appropriate measures, if any, for an improved working of the Collegium system. So they do realize that there need to be appropriate measures to be taken. Now, we are disagreeing on who should take those measures. I understand that. There's another, let me put it this way, member of the public, the direct stakeholder in this process, who wants to speak. Dr. Ranganathan, yes.
Good evening, Rahul, and thank you for having me on this exalted panel of luminaries. And I dare say, I of course speak as a layman here, and if I am hauled up for contempt, may I request some of your panelists to please represent me pro bono. Look, I'll be very honest. The judicial system is broke, but it shouldn't be fixed by politicians alone. Let me explain. It's a scintillating debate, and I dare say today's topic throws more questions than answers. But one, 70,572 cases are pending in the Supreme Court, 5.91 million pending in the High Courts, 41.51 million cases are pending in the district courts. Worse, out of these 47 million pending cases, 182,000 cases are as old as 30 years. As many as 244,001 pending cases are of rape and child sex offences. India has just 20 judges per million population, worse than sub-Saharan Africa. 38% of High Court and 21% of judicial positions overall lie vacant. 76% of all prisoners are under trials. As I said, the wheels of justice aren't just grinding slowly. Rahul, they've come to a halt. And one of the primary reasons is judicial appointments. Yes, of course, this system where judges appoint judges needs a serious overhaul. Around 50% of High Court judges and 33% of Supreme Court judges are related to senior judicial members. Only 250 families have ever sent judges to the Supreme Court. Conflict of interest is rife. At one point of time, 34 judges of a High Court had relatives working as lawyers in the same court. CGI Khare admitted corruption was rampant in lower courts. 9 Supreme Court judges said there was corruption in higher judiciary, a fact disclosed in the Supreme Court itself. And yet, no one but the judiciary, through Article 235 as well as the 1997 declaration, can investigate judicial corruption. Quite obviously, judicial appointments need to be overseen by a neutral party too. But here's the thing, are politicians neutral? Anything but. Did you know the Congress blocked appointment of judges if they were in any way associated with the ideology of the RSS, or even so much as attended the funeral of an RSS person as Justice Chandurkar did of Golwarkar? And let me not even go into how many Supreme Court verdicts did the Congress overturn because of appeasement and placating vote banks. The Shah Bano verdict, the bank nationalization verdict, to name but two. It is obvious that if they overturn a judge's verdict, they'd much rather not have that judge there in the first place.
Viewers, I have a point of view, and I'm not afraid to look you in the eye when I express it. This is because I know that it's based on an honest, hard fact. A hard fact is uncompromised, just like me. On India Upfront, get the power of the hard facts. Remember, every good argument is based on hard facts. It's just as simple as that.
Whenever news breaks, you will see us. Process it, analyze it, and broadcast it. After the spot reporters, we are the first responders. We are at the front line
of every news event.
We are situation analysts, raw, live, and unedited. Pure news, pure passion.
Times now, action begins here.
Aren't you sick of the same old news debates? We get it. We know you want people to talk to you, not talk at you. So we built a space for people like you. A place where your agenda becomes my agenda. Where we keep our eyes and ears open to issues that really matter. But we're all about calmly laying out the information, no unnecessary aggression, no bluff. Filtering out the trash to bring you the truth that isn't partisan and pulls no punches. No WhatsApp gyan, no diktats, just unvarnished facts that you know are honest. Watch News Our Agenda with me, Padmaja Joshi, weeknights at 10 p.m. only on Times Now.
Explosive, exclusive, and beyond.
The show that gets you the inside track.
A deep dive into stories that matter.
Raising questions you won't ask.
Your voice is now our voice. Watch Blueprint with me, Meghna,
and Pranesh
at 6:30 p.m. every weekday.
only on Times Now.
An eagle-eye view on Karnataka. A state whose politics has national resonance.
Tracking every story to the last detail.
Ahead of 2023 state elections, we are your destination for all things Karnataka.
Watch Inside Karnataka every weekend only on Times Now.
The war against COVID is far from over. As cases surge worldwide, it's time to renew your WMD pledge. Washing, masking, and social distancing. Join Times Now's campaign. Renew your WMD pledge.
Knowledge is power. Don't let it get lost in everyday noise. That's why we believe in detailing, so that you don't just hear the news, you know. When the nation wants to know, is with me, Padmaja Joshi, weekdays at 7 p.m. only on Times Now.
Let me just come back to also the fundamental point. Mr. Khurshid, let me bring in Mr. Ranjit Kumar, Justice Dhingra on this, and then as we build, I'll bring in the others also for a second round. Mr. Khurshid, I just want to ask you, plain speaking, do judges have no role in reforming the broke system? Are they absolved from doing so, ironically, on the back of a verdict passed by themselves, upon themselves? How does this work? Please explain, because in our stream, if a system, I just heard, sorry, I just want to make it a little personal. The judges very recently suggested that the media was flying off the rails, especially TV anchors, etc. They were completely out of control. And if they were out of control, then they should be benched. And the decision was left to one part, the industry itself, or the body that obviously is part of the oversight mechanism, so to speak, or then, of course, the government, which is, of course, a crazy concept to advocate. But let's say that we were asked to regulate ourselves. In the same way, are the judges, do they have no role in reforming the system? Should they just wait for the executive to ramrod a bill, etc., try again, what have you?
Nobody ever said that, and I don't think the judges believe that to be so. But there is a system. Judges have to respond. They do suo motu things, but the suo motu procedures are also in response to something that has happened. So it's not a system that is an organic system that works by itself, but it's a system that needs to be triggered by something from the outside. That's how adjudication works. Of course, the judges have a responsibility, but my only problem is that many things that are said about reform are only on the surface. We need to understand a lot more that is deeper, and many of the things that have been said in this discussion, I believe, are extremely edifying and are extremely rewarding in trying to understand the challenge that there is in front of us. And the challenge in front of us is not just how we select judges and who selects judges, but also how do we democratize the whole process? How do we decentralize the whole process? And how do we reach out to a larger number of people in the talent pool that exists in this country, both amongst lawyers and amongst laypersons? This is not something which in a half an hour, 45 minutes discussion, we will find a solution to. Judges have a responsibility, public has a responsibility, politicians have a responsibility, the media has a responsibility, and I think we should all be willing to accept responsibilities for ourselves, and then perhaps we will move forward. There are no easy solutions at all. There is nothing like putting in a coin and getting something back and say, here's reform, I've done reform. Reform must happen, but reform is not an easy thing to do. And perhaps what you require is an all-party conference to think about how we should move ahead with our judiciary.
Right, it's interesting because, Mr. Khurshid, a few years ago, 5 justices walked out into the open. They arranged themselves in a semicircle in the lawn of the Supreme Court, and they called for reform. Some talked about bench fixing, very serious charge, bench fixing, viewers. And I remember the opposition said, they're right.
Yeah.
They're absolutely right, these people. There's bench fixing going on. One of them happened to become the Chief Justice. The matter is closed. No one knows what's happened. So as I asked Justice Dhingra, why are we being so, let me just say, giving such a wide berth to the judges? Why can't they, in all the spirit of accountability, transparency, and Justice Chandrachud is known to be a person who has said that, look, I'm going to put certain values far above considerations that are not in conformity with the public interest. Why can't he lead the way? Why can't he walk across, perhaps, I don't know, to the Law Minister's office and say, let's have an honest conversation. I come before you, let's work out a system. Justice Dhingra. Or is he absolved? Mr. Hegde, I'll bring you in on that. I know that you're dissenting with me, so it's good. I'll just bring you in. Yes, Justice Dhingra, go ahead.
Yes.
Yeah.
Mr. Rahul.
Yeah.
Mr. Rahul, only that person can lead judiciary who has actually seen the woes being faced by the common man. Today in the judiciary we have people who have no touch with the common man. They do not know, as Mr. Ranganathan has given figures, a situation is much more worse. Even a small case, of a check bounce takes 5 years to 10 years in our courts. And that also with so much disappointment that people have become, they are openly saying this system has collapsed. You are only looking at Supreme Court. But look at right from bottom till Supreme Court, we don't have judges.
Yes.
We have babus who are there to spend their time, who are there, in trial court, they are given units, they fulfill that criteria of giving units per month, and they think their duty is over. At High Court, they think they have come to enjoy the life, they enjoy, and then they try for Supreme Court or for post-retirement jobs, and after that their life is over. Same is Supreme Court. In Supreme Court, we have great babus as great bureaucrats who think they have achieved the achievement of life. Now nothing is to be achieved. Why should they worry about them? There is no judge who worries about this country, who wants to bring reform. Otherwise, it is within their power to reform at least procedures in Supreme Court and in High Court and in trial courts.
Right.
They don't even do that. The procedures are not to be reformed only by executive.
Yeah.
They are to be reformed by judges.
Exactly.
They don't do that. They don't make performance simple. They don't do their duty even of
at one
proper
time,
invigilation and
Justice Dhingra, at one time,
of trial courts.
At one
they
time,
don't do supervision of
absolutely. At one time, Justice Gogoi, Justice Chalameshwar, Justice Lakur, Justice Kurian Joseph, 4 judges walked out into the open. They took the sunlight, which is the best antidote, and said, there's a problem. But they haven't fixed it. They went back quietly into their chambers and they never fixed it. So I want to bring in senior advocate Mr. Hegde. My problem is silence is allowing people with vested interest.
Just a minute. All these judges.
Yeah. Yes. Yes. All these judges. All these judges were chief justices at some point of time. It's true.
Were chief justices at some point of time.
Yeah.
What they did in their own High Court, what reform they brought, please ask them.
Okay. Well, they won't subject themselves in the manner that you are, sir, to a question and answer session. I hope they will, and I will approach them, and I will say that Justice Dhingra will also be part of the panel. I'll ask you these questions, but one second. Let me bring in Mr. Hegde. Mr. Hegde, the silence on the part of the judiciary, Justice Chandrachud has spoken on so many issues. So did his predecessor. They got onto every lectern available and they lectured the world. But I want to ask you, the silence today is allowing people with vested interests to paint the picture of an embattled judiciary at the mercy of a crooked executive. How is this even fair?
Okay.
Mr. Hegde.
Point one, you spoke about the 5 judges. who walked out. Why did they walk out?
I don't know.
Justice Gogoi is on record saying that it was the Loya case. Which way did the Loya case finally go? So let's not talk about...
Mr. Hegde, they talked about real issues. No, forget about their motives. When they came out... No, 1 second, Mr. Hegde. That's not fair. That's not fair. That's not fair.
Try to derail it.
No. That's not fair. They all came out and they made some very pointed observations about deficiencies. I'm asking you, sir, as a practicing lawyer, have those deficiencies been fixed?
The point is that there are deficiencies in the system, there are deficiencies in the personnel.
Now you're equivocating. You see, this is the kind of...
Don't shut me down, Rahul. Don't shut me down, Rahul.
I'm not.
Let me finish what
I wouldn't dare to.
Don't interrupt. So the point is this. As far as selection of personnel is concerned, yes, the government can make suggestions. The judiciary will consider. If they think that Rahul should be made a judge, the judiciary will consider. That's a different thing. But to give the government any say of totally blocking any appointments, even today the Collegium...
I don't think the NJAC didn't bat for that. You know that, Mr. Hegde.
Just a minute.
Yeah.
Even today, the Collegium has not made certain judges, High Court Chief Justices, who the government thinks are opposed to them. They have not been brought to the Supreme Court. The Collegium has worked in collaboration. Judges don't look for confrontation. As an institution, they are more status quoist. Despite that, we now have a government which needs total obedience.
Look, those are now very subjective. Now that's a very subjective. Hang on, Mr. Hegde. Mr. Hegde, you can. I'm not stopping you. You're absolutely right in saying that you can apportion blame and park it completely at the doorstep of the executive, and you're within your rights to say all of that. But you know that won't be fair on the conversation we're having. Yes, Dr. Ranganathan is raising his hand. Yes, sir. Please, go ahead.
Yes, thank you very much.
Yeah.
Not to interrupt this exalted panel, but just to say I have tremendous respect for Justice Dhingra. He's like a father figure, and he's made some remarkable judgments. But can I please slightly disagree with him on this count? Because the tragedy of this country, Rahul, and I speak as a layman here, is that suddenly all Indians find their voice, conscientious voice, coming from above, or wherever it may be, once they retire. So a bureaucrat will suddenly say, these are the loopholes in the system when he's retired.
So let me bring in former SG Ranjit Kumar on this question. Mr. Kumar, is the government completely today at fault? It's a very simple question. Let's get to the bottom of it.
Well, let us put it this way, that the government is not at fault at all. When Mr. Sanjay Hegde also says the same thing, that the government can make suggestions. Now, what I am saying is that what is the meaning of consultation? Is consultation to be a superiority of a collegium, or consultation is that a process between the two when people consult each other and do something? So therefore, if there is a consultation, that the word consultation has been given a meaning today by 9 judges, which according to me does not go into the common sense that consultation will not mean that whatever I say you have to do it. So if the government is saying that I want to consult, you should consult me also, what is wrong about it? That's all. And secondly, I don't agree with the example of cricket given by Mr. Hegde, because the cricketers are playing and everybody is watching the game on TV. So therefore the persons who are selecting are knowing and seeing everything. Where are you seeing all this on TV of all the judges being appointed? Where are you seeing their performance?
That is why.
You have no place to see their performance. It is now that we are seeing Constitution Bench hearings to be on TV.
Well, let me even say, sir, when you're talking about opacity,
is not right.
When you're talking about opacity, I don't believe that taxes
Yes.
The judges even have to file taxes. It's left to their better judgment. Even that leeway is given. That's what I'm told, viewers.
That I'm not aware of. I don't.
Yeah.
I'm not aware. The law minister, former law minister, would know better.
Okay.
I have no idea.
Okay. Well,
So therefore,
Rahul, like we have
so,
for
but
every other important domain in life.
Yeah.
For example, be it medicine, be it armed forces, be it fighter pilots. Everyone goes through a rigorous merit-based selection.
Well, true.
Now, if the judges were to go through that, you don't need the role of government at all.
Exactly. And
But do they?
And I request the Chief Justice of India and others, I'm sure they don't watch television because they do say that it clouds their judgment. So I'm sure they don't want to watch something they find reprehensible. But if ever word does get around that there was a discussion such as this and there was an anchor asking them to perhaps introspect, they might consider in all modesty. Thank you very much, viewers.